Good afternoon to our distinguished panelists. Good afternoon to our participants, and thank you for joining us in this series 2 of the Law in Crisis seminar organized by the Faculty of Law of the University of Ghana. I have with me the host, the faculty's head, who is in the person of Professor Raymond Atuguba. We'll take a few words from him and then we'll set the ball rolling. Thank you, Prof, please.
Thank you very much, Diana. Good afternoon, ladies and gentlemen. My name is Raymond Atuguba, Dean of the School of Law, University of Ghana. On behalf of the school and the faculty, I'd like to welcome all of you to the second edition of the Law in Crisis series of webinars organized by our school. The post-COVID-19 world is going to be a different one. Today we're discussing executive powers in the era of COVID-19. I saw in The Economist that over 88 countries, the leaders of over 88 countries, have so far enhanced their executive powers in the face of the pandemic. That is very significant. We have an excellent team of experts to discuss this topic with us today, and I would not want to say too much. I'd just like to hand it over to them. Before I do that, I'd like to thank our alumni who have been doing all the heavy lifting to organize these events. I particularly want to mention Mause Oliver Bakavamawo and Samuel Alesu Georgie for helping in this initiative. We also have a team of students and other alumni working and assisting them. Ebusian, Nana Boachi, Gregory, Benedicta, Edinam, and Prosper. I wish us all a very fruitful discussion. Back to you, Diana.
Thank you, Prof. Our dear participants, kindly let me introduce to you, as you may know, our panel members for today. We're very privileged to have in our midst Professor Edward Kwashiga, who is the former Dean of the School of Law, the University of Ghana, the institution hosting the current seminar. We also have with us Professor Henry Kwesi Prempeh, who is an Executive Director of the Center for Democratic Development, Ghana. I'm also privileged to have my own Mami Abna Mensah Bonsu, who is a PhD candidate at Oxford University. We also have Dr. Peter Tukpari, formerly of the School of Law, University of Ghana, but currently the Dean of the Faculty of Law, University of Cape Coast. We are expecting to have Professor P.L.O. Lumumba, also a former director of the Kenya School of Law, join us in a few minutes. By way of procedure, I'm going to pose questions to our panel members who shall then engage us. Of course, we also relish the very rich questions, comments that will come from our participants, and I'll encourage you to use the Q&A button to send me your questions. Please note that we're also live on YouTube and Facebook, and so you may join if you're unable to join us here on Zoom. Prof. Kwashiga.
Yeah.
Now, can you tell us a little bit what is the nature of the emergency powers that the executive branches of Ghana, the government of Ghana, have assumed during COVID-19?
Thank you very much, and good afternoon to all participants. It is important we appreciate what emergencies are.
Right.
Constitutional law perspective. Human beings as we are, it is impossible to anticipate every situation that may affect us. Therefore, when we draw up constitutions that are to bind us, according to which we must all conform, particularly the executive, the legislature, and the judiciary, and all of us, when we draw up constitutions, we insert in those constitutions provisions that should take care of necessity situations. That is why we have, for instance, in the 1992 Constitution of Ghana, Article 31, that deals with emergencies. If we take into account the fact that constitutions are intended to guarantee respect for the rule of law, that those who govern must govern according to the law, then emergencies in a way become an aberration. But definitely there will arise uncertainties. There are necessities that will require certain actions. Therefore, necessity situations and therefore emergencies become important. But it is important that we draw a distinction between what we may describe, and I think Professor Datiba drew the same distinction between what we may describe as low-level emergencies and what we may call high-level emergencies.
Right.
High-level emergencies, one may describe as emergencies that have the potential, that possess the potential of undermining the very existence of the Constitution and therefore the nation. You can think of as many of them as well. Perhaps war may be the most immediate one that comes to mind. Then there could be other emergencies that go with the name emergency, but may not be of such nature as to be described as having the capacity to want to undermine the stability of the nation. They're emergencies anyway, but we cannot classify them as high-level emergencies. Now, this second category of emergencies, one would not want to see resort to the state of emergency situation that we have in Article 31. These low-level emergencies must be handled according to the ordinary legal provisions. And if you look at our Constitution, even with provisions in Chapter 5, that is the chapter on the fundamental human rights, we have references to those kinds of situations, what you may describe as emergencies, but low-level emergencies that Parliament could make a law to take care of. I believe that is why we have, for instance, Article 21 plus 4, I think E or so, yes, according to which the Imposition of Restriction Act was promulgated. Now, the question is, should the president have gone under Article 31 provision, or is it okay, is it proper that Parliament decided to promulgate the Imposition Restrictions Act, giving powers to the president to proceed to manage the COVID-19 situation? Personally, I would caution against unnecessary resort to Article 31. Because as I said, Article 31, which has to do with state of emergency, gives so much powers to the president to derogate from almost all of our rights. In fact, if you look at the Emergency Powers Act, if you look at that law, it gives powers to the president to the point that he can let me get the correct listing, that the president can take actions that to suspend the operation of any law. These are far-reaching powers. And to me, those powers should not be exercised lightly. So under this current pandemic, is it okay that we have Parliament giving powers to the president under the Imposition of Restriction Act? I would say yes. But then, I have a problem with the nature of the act itself. The act his powers to the president, but then fails to define specifically the conditions under which the president could exercise those powers. The act gave blanket powers to the president, verging on legislation. The act provides general powers and then leaves it to the president as and when he thinks fit to provide the details. If you look at Article 19 plus 11 of the Constitution, if I may read it for the benefit of our listeners, participants, yes, no person shall be convicted of a criminal offense unless the offense is defined. My emphasis on defined, and the penalty for it is prescribed in a written law. Right. By giving those general powers to the president, for the president to define what the specific or exact offenses should be, has abdicated his powers, which is not permitted. So yes, we should not, under these circumstances of the pandemic, go under Article 31, because that will confer too much powers on the president. The Imposition of Restriction Act perhaps is the proper way to go, but then I think that also falls short of what is expected of Parliament. Then in addition to that, if you may permit me, yes, we have a number of legislations already existing. For instance, the Public Order Act and also the Public Health Act. Those acts make provision for certain situations of emergencies, but then they give powers to the ministers, the responsible ministers, Minister for Health, in case of public health matters, and then Minister in charge of the Interior under the Public Order Act. If I were president, I would want to be in charge of this COVID issue. So yes, I would want to have powers given to me by Parliament so that I can face the pandemic from my end, not leaving it to my ministers to handle under those other pieces of legislation. But as I said, I think Parliament abdicated its functions by giving an open-ended nature of powers to the president. I think I will stop here for now.
Right, thank you very much, Prof, on that. Mami, let me come to you. You know, Prof has tried to indicate the types of emergency. He classifies them as low-level emergencies and high-level emergencies. And in his opinion, the pandemic qualifies to be a low-level emergency. Would you share same thoughts on that?
I mean, given Prof's definition of a low-level emergency as one that does not affect the constitutional, is not an existential threat to the state itself, I would agree that the pandemic is a low-level emergency to the state, even if it's a high-level emergency for its citizens. And sometimes we forget that there's a distinction between the state itself and its individual citizens. And so when Prof says this is a low-level emergency, he's not saying it's an unimportant event. He's not saying this is not a big deal. He's saying that at the level of existential threat, this is not an existential threat to the state. And so I agree with that. What I'm not certain I completely agree with is whether the emergency powers give Article 31 gives more power to the president than the Imposition of Restriction Act does. Right. I do agree that we should be very careful about triggering states of emergency. It's one of those exceptional circumstances in the Constitution that you don't want to encourage executives to treat as a plan B for doing things that they want. So you do want to restrict the number of times that a government feels comfortable invoking that article. Nevertheless, I think that article contains far more constraints on the president than the Imposition of Restrictions Bill does. it involves Parliament significantly more than the act does after it gives him the powers. So if you look at the emergency Article 31 clauses, after they've given the president the powers, he has to keep informing Parliament. He has to keep coming back and getting their buy-in as he goes along. If you look at the imposition of restrictions bill, it's go and he's done. He doesn't have to come back. He doesn't have to explain anything. And the circumstances are unusual. So I'm sure every constitutionalist is hesitant to say, down with the president. The circumstances are unusual, and we do want him to be able to act and respond quickly. We do worry, though, that the speed with which he can act that's the whole point in separating powers, to slow down the speed with which an executive can override the people and take paternalistic decisions. And the imposition of restrictions bill is very worrying in that regard. It treats this as an existential threat to the state and gives an almost frames the conversation as if it were the president against the country, against the people, and he has to do what he can and use whatever force he can and must. And the penalties, for instance, are so draconian that it does not feel like an act enacted for my protection. As a citizen, I don't feel better protected when I see that the state says, if it tries to protect me and I don't cooperate, then I have to find 1,000 penalty units or a minimum of 4 years in jail because the state was trying to protect me and I didn't cooperate. I agree, if I didn't cooperate, there should be some measure of censure, but 4 years in jail, that doesn't make me feel like the act was, that I was the beneficiary of the act. It makes it seem like the citizens are against the people, the state, rather than that the state and the president are acting to secure the welfare of the citizenry.
Right, so do I hear you to be saying that you'd rather Article 31 of the Constitution was invoked rather than the imposition of the Restrictions Act?
No, I'm saying I do think that Article 31 should not be invoked casually, but I think the imposition of Restriction Act as it stands now is worse than the Article 31 would have been. So in the end, in avoiding a situation where we get our executive overly comfortable with arrogating powers themselves in the name of emergency, we've given them an even less difficult route. That's worse. And the problem with the bill, as Prof was saying, was the lack of limitations of any sort, even a time limitation, so that if you look at the constitutional provision, it has sunset clauses. If Parliament doesn't ratify, the state of emergency expires automatically. But the act is an act of the Parliament of Ghana. Until it is expressly repealed, it is in force.
Thank you. Now let me come to Dr. Topari and Professor Kwesi Prempeh. Would you consider the current measures, COVID-19 measures that have been implemented by the president as one that will normally be imposed during a state of emergency? And if yes, I mean, what would you be able to rationalize how the president has chosen not to declare a state of emergency?
Who goes first?
Please,
okay.
Prof. Go ahead.
Okay. So having listened to, I think I share the sentiments generally expressed by Mame Mensah Bonsu on this matter. I do not think that the pandemic, COVID-19 pandemic, or the version of it could be considered some low-level emergency that does not necessitate the triggering of Article 31. On the terms of Article 31 itself, under Article 31, Clause 9, the circumstances under which a state of emergency may be declared include a natural disaster. A natural disaster would be massive flooding, for example. Massive flooding that makes it very difficult for normal activity to be carried on. If a natural disaster is actually within the contemplation of Article 31, I have a hard time trying to rationalize why a pandemic, a contagion that actually just spreads very rapidly and whose whose manner and behavior, virus whose manner and behavior is still evolving and is not even well known, cannot be considered, right, as falling within the framework of Article 31. Also included in Article 31 would be any action taken or immediately threatened to be taken by a person or body of persons calculated to deprive a community of the essentials of life. So basically, in the event of some group of people deciding that they will hoard certain essentials, they've captured certain a particular inventory of resources that we need to live on. I mean, these are the kinds of things. So if these things are included in what could trigger a state of emergency, it is hard for me to think that a pandemic declared by, an epidemic declared by the WHO as a pandemic would not actually be covered. So in my view, it is covered. And I think that the Constitution doesn't really make the distinction between this low-level emergency and a high-level emergency. I think emergencies are everywhere, at least everywhere where there's a written constitution. Emergencies are everywhere constitutionally contemplated and are therefore regulated by the Constitution. And actually, rather than relaxing the controls on executive power during this period, emergency provisions typically actually strengthen them. So while they enable the president to act speedily, right? So for example, under Article 31, the president is allowed to proceed first with a proclamation and then go to Parliament within a time setting to get that act, all the measures that have been taken per the proclamation ratified within a short period of time. So the president is allowed to respond quickly, swiftly to an emergency, and then go to Parliament for ratification. But beyond that, you can see that there are a number of strictures placed on the exercise of emergency powers, including constant referral back to Parliament. There's a sunset clause that lapses, and then you go back to Parliament. So I think that there's a particular constitutional regime that has been enacted in Article 31. And what we have done with the Imposition of Restrictions Act is that we have allowed the president essentially to circumvent that regime. And it's important to note also that the Imposition of Restrictions Act, as enacted, is not a COVID-19 specific law. It is not. It actually is a law that governs all kinds of emergencies, right? If the president had proceeded under Article 31, he would have been required to actually make a COVID-19 specific proclamation and then report on the measures and the progress to Parliament periodically. So Article 31 contemplates a specific emergency, case-by-case basis. You make a proclamation, and once you trigger it, it puts you under a certain regime that requires you to constantly refer back to Parliament for Parliament to be in the mix and to review your actions, as things progress. Under this new regime, this new statutory regime, this is not a COVID-19 specific law. It allows the president, once he defines that there's an emergency, right, based on what the statutory criteria that have been laid out, once he deems that there's an emergency, to immediately proceed by the instrument, which is essentially a decree, so to speak, and then not to refer back to Parliament at all. I mean, the only remedy here, it appears to be just judicial review, right? So Parliament is completely taken out of the question. It's completely taken out. When Article 31, in fact, would have inserted Parliament into it in a very significant way. So I am worried by the resort to a statutory regime that is not compliant with the strictures imposed by Article 31, as opposed to going straightforward. Yes, I understand that this is not supposed to be resorted to casually, but a pandemic declared by WHO of this nature is not a casual thing. It doesn't occur. This is a once in a lifetime thing. None of us has actually witnessed a pandemic before. This is the first time in our lifetime that this is happening. It doesn't happen frequently. So this idea that if you use this to address a WHO declared pandemic, you would be resorting to Article 31 casually. I don't see that at all. If a natural disaster, right, a natural disaster, huge flooding of the country is not a casual resort to Article 31, then I have a hard time seeing resorting to Article 31 to deal with COVID-19 pandemic as casual resort. Right? So I definitely am not of the view that we should have gone for a new statute. If the president wanted to lead this effort, Article 31 makes him the leader of the effort. In fact, I don't see any more. I mean, this is the best way for the president to actually take full charge of the situation. I mean, the president can lead under Article 31, just go swiftly, and then you take the legislation, so-called proclamation, to Parliament. If it's ratified, then you go on 3 months, you come back, Parliament, this is what we are doing, this is how it's going. Okay, go ahead again for another month or two. So that kind of role for Parliament, for me, that has been completely eviscerated under this statutory regime is what worries me the most. And also, you should also note that under 31, the proclamation would have been declared in the first instance upon the advice of a Council of State. All of those things are dispensed with now. The president proceeds on his say-so, and yes, there are some statutory guidelines, but if you think he has breached them, your only recourse is to go to court.
Right.
I don't think that's good enough.
Thanks, Prof. Let me come back to them. Perhaps if you can, are you able to possibly rationalize why the president did not resort to Article 31?
Is it back to me?
Yes, back to you, Prof. Spencer.
I have a hard time, I really have had a hard time divining the motive.
Right.
However, I've seen some kind of communication on social media to suggest that the executive did not feel that Article 31 applied. And that actually, the reasoning that has been adduced for that, that argument sounds to be a bit bizarre. So I am told that Article 31, Clause 9, which talks about, it says the circumstances under which a state of emergency may be declared under this article include a natural disaster and any situation in which any action, that because it does not name an epidemic, because it does not expressly name an epidemic, that they had a hard time trying to fit the epidemic under this provision.
Very well.
Article 31 does not even name war, which is the most extreme of emergencies. Are we then saying that Article 31 doesn't apply to a war situation? Of course. When Article 31 says include a natural disaster, all they're telling us is that if we were in any doubt that a natural disaster was included, well, this settles it. It is included, right? So the more obvious ones that are not mentioned, like war and a pandemic, are probably too obvious to require mention. It is not to say that they are not included. It says include. It doesn't say include exclusively. It just includes a natural disaster. So if you are doubtful that the president could declare a state of emergency based on evidence of massive flooding in large parts of the country, well, this disabuses your mind that in fact the president does have the authority constitutionally to declare a state of emergency based on a natural disaster like massive flooding. But that is not to say that war, which is not named here, how then should we operate under war? Apparently, under the Imposition of Restrictions Act, war is now basically has been actually put under the Imposition of Restrictions Act. Essentially, Article 31 is no good anymore, right? And if you were a president, given a choice between a legal regime that binds you to checks and balances with Parliament and the like, and one that leaves you free to go as you wish, which one would you choose? You would always choose the latter. And that's where my worry is, that this is a perpetual grant of authority for the president to make determinations as to when an emergency has arisen, and then to proceed with a decree and to rule by decree. And that, I think, it really wreaks havoc to the constitutional scheme here. I mean, I don't know any other reason why you would not, you know. So I think if it is indeed true that they believed that they couldn't really proceed under 31 because an epidemic of this nature did not fit under clause 9, then it's a gross misreading of the provision of the Constitution.
Right. I'll come back to you. I think the point is well made that you cannot divine, you can't explain the rationale for that. Let me go to Dr. Tupac.
Yeah.
I think the measures that have been undertaken, have been implemented currently would have been different if a state of emergency was declared.
Well, first of all, let me begin by saying that any rationalization that you will be given in respect of this particular act that is being enacted, and subsequent to that, the executive instruments, all we have to be an argument that is dependent upon the architecture of your constitution and your peculiar circumstances. So there's no way you can universalize facts so far as this pandemic is concerned, because we are in Ghana and our situation is peculiar. And the constitutional architecture of this country as compared to others, for instance, in Nigeria, they have the emergency provisions. They also have what we have, which is Article 21 situation, and they call it the human rights derogation provisions. But they have decided not to go to the constitutional provisions. They've decided not to go to the human rights provisions, but they went to the Quarantine Act of 1928. In our circumstance, the president and maybe the leaders of this country thought that going through the emergency provisions, which is Article 31, might not be proper. That is the thinking, of course. And what is proper is Article 21. So there's a valve, there's an alternative, a window. And, right. and various constitutions have actually provided for differentiated approaches to these things. Right. So there's no watertight argument that it must be this, it must be that. It's just that you have to evaluate the circumstance and see how you apply your context. Are you getting me? Are you hearing me? Or I have a problem?
No, Doc, I'm getting you loud and clear. It's fine.
Okay, great. So in our context, and let me say this: in the emergency situation, as Prof has said, people have tried to classify emergencies. They would even classify them as low, middle, upper. It depends on how you, and that's how the relevant literature is all about. But it all depends on what kind of measures are you going to take, and what is the definition of this low, middle, high? Who defines that? Would that be the executive? Would that be an independent body? Would that be president, or would that be the legislature? In our context, we have a dualistic approach when emergency powers are engaged. The dualistic approach is that the party actually granting the emergency power is not the party exercising it. And in this case, after the 7 days, it is Parliament that will authorize the exercise of emergency powers. And then the one who is going to exercise that emergency power is the executive, that is the president. And like Mami said, there is a window for control. There's a window for monitoring to ensure that the powers that are conferred are not abused. And the monitoring, investigation, evaluation is all dependent on the facts. So if you have to rationalize this, the president might think that no, the emergency situation or the emergency provision is not the best way to go. And let me point out this, that the people who are making the human rights argument that the Restriction Act is an abuse of human rights. The clause 10 of Article 31 is very clear that human rights from Article 12 to 30 may be suspended. In fact, can have some kind of effects when emergency powers are invoked, so far as the Constitution is concerned. When you come to 21, it is not only about Article 21. That is the derogation provision. So the limitation is on one provision, as compared to the derogation, the possible derogation when you go to Article 31. So you may have some kind of less intrusive window as opposed to an aggressive window which potentially can affect human rights. So we should think about that very carefully. Now, let me state something about rationalization. The executive may say that, yes, 21 provides us a quick and a decisive instrument to be able to deal with something that's sudden, that has just dropped. Whether or not you agree with that, it is up to you. It may as well say that, look, we just have to focus on the derogation provisions on Article 21, which is less intrusive because we are just dealing with fundamental freedoms as opposed to all the rights from Article 12 to Article 30. And that is less of an intrusive window. Then the definition of the facts, the measures taken by the president, whether or not the state of emergency exists or that warrants the invocation of Article 21 is not conclusive because the provision says measures that are reasonably required. And that's a test for anybody to look into. If the test, you know, we may say that, okay, the court looking into it can come out with that. Yes, citizens will not like.
How they do. Dr. Tukari, can you hear us? Right, let me while we wait to see if Dr. Tukari will get him back on track, let me quickly come to Mame, and I mean just in 1 minute, and Professor Kwashiga as well. Do you think the measures that have been imposed under the Act would have been
minimalism that these are required? It's not.
Doc, I think we are losing you, the network. So, Mami, let me come to you. Do you think the measures that have currently been implemented would have been different if a state of emergency had been declared?
I mean, given that we don't...
To Act 10, 12?
I'm sorry?
Can you rationalize why were the imposition of Restrictions Act instead of Article 31? Would you be able to do that?
In terms of the measures that have been taken, it's hard to say that they would have been different under the Emergency Powers Act because they are in response to the data that they have. What would have been different is the methodology and the participatory nature of such decisions. If it had been under Article 31, it would have been the executive and the legislature agreeing that these measures are necessary. And perhaps I can see the slight disadvantage to the executive that the executive could see in going the emergency powers way, because it requires quite a consensus to be able to move under the Article 31 powers, because as Professor HKP said, there's more control rather than less when the state gives you emergency powers. And so there would be more consultation involved, perhaps more people's buy-in. I can see how an executive would think that would slow them down. I'm not saying I see that is a concern that should be engaged, because the Constitution did consider the dangers of having an executive able to move without consultation versus one that must consult. And so in terms of the measures themselves, it's possible we would have had exactly the same measures.
Same measures, right.
Our concern is not that the measures themselves are are unjustified. Our concern is that we have no way of knowing how far it will go. There's no way to roll them back in the legislation. The imposition of restrictions bill gives the president the power to take the advice of a relevant person. It doesn't define who relevant is, right, which means it could be anybody from the chief medical officer, the WHO consultant, to his mother. Not that mothers are give bad advice, but you can see why this is problematic, that he need only take a person he deems relevant advice in order to impose such far-reaching restrictions. So I think the thing that we would like to communicate as constitutionalists is we're not so much opposed to the measures themselves as we are opposed to the speed and the ability to impose them without restraint. That's the concern. I don't have all of the data, so I don't know whether it would be better for us to, I can opine that lockdowns are not effective in our informal settlement. I can see anecdotal evidence, but perhaps he's operating with actual statistics and I'm not. So he is in a position to take some decisions that I may disagree with. But it is the opportunity to participate in that, to restrain him if we don't as a people agree. That's our concern. And even more critically, when the pandemic passes, because this, as HKP said, is not a COVID-19 legislation, it forms part of what becomes the existing law under Article 11. And then any president can do anything they want, invoke any relevant person's advice under the imposition of restrictions bill. Right. That, I think, is our concern, more so than whether the measures are justified.
Right. Let me come back to Dr. Atsupa. I think we have him back online. Doug, do you want to conclude the points that you were making before we lost you?
Yes, I actually want, yeah. Now, the other flip of the argument, that apart from trying to rationalize it on quick, decisive platform to deal with an issue, the problem
I think we're losing Dr. Tupari once again. The UCC lines are not being kind to us. Prof Kwashiga, let me come to you until we get
quite apparent on what.
Doug, we appear to be losing you. You appear to be going in and out of the network. Yes, Prof Kwashiga, please, how would the state of emergency be different from the current COVID-19 imposition?
Yeah, you see, I am very cautious about the call for resort to 31, because 31 gives so much powers to the president, because when parliament, yes, there are restrictions from parliament, but once parliament gives that power, the president becomes so much powerful that all our rights under, from 12 to 30 could be interfered with. It is, as Dr. Tupare said, the restriction is no longer limited to only Article 21. It will mean that the president could just do anything, whether it has to do with COVID. In fact, so we have to be very, very careful. We must limit our presidents. So that's why I'm saying that the imposition of restriction act perhaps is the best way to go, because it is surgical, it is limited. It looks at the restrictions under 21. But then I have a problem, as I said, let me reemphasize. I have a problem with the way Parliament provided for in that law. Parliament could have done better. Parliament could have infused into that act all the restrictions which we have in 21. Sorry, which we have in Article 31. And that would have been fine. But now it seems we have a general provision that gives the president so much powers, but still going under 31 would be a very sad mistake. You have the example of Hungary.
Right.
A member of the European Union. That prime minister has so much powers, emergency powers, that he's now even affecting the rights of journalists. Is that what you want to do? 31 should be resorted to very, very, very rarely. And in any case, when we talk of low-level emergencies, if you look at the Public Health Act, the Public Health Act talks of emergency. When there is an epidemic, the minister in charge of health can declare an emergency, and then with it follows various steps, including You can be asked to stay at home. You can be kept somewhere. All those are there. So yes, we can have low-level emergencies. In any case, don't we have meningitis in this country? And how many people haven't died out of meningitis compared to COVID? And have we declared emergency, even ordinary emergency?
Right.
Emergency powers under 31 should not be toyed with.
Very well. Right. Thank you. Dr. Tupari, I think we still do not have it. Yeah, so flowing from Mame's statement that we are stuck with at 10-12. So let's proceed from there. Now I'll come back to each of the panelists. What are the implications of the executive powers on human rights? I would want us to consider at 10-12, as well as Section 76 of the Electronic Communications Act on the right to free speech. I also want us to look at the Executive Instrument 63 to focus on the right to privacy. So let me start with Mame this time. What are the implications of the executive powers that have been exercised so far on fundamental human rights?
So when I first heard that the president had issued EI 63 requiring, was it 63 or 65, requiring the telecommunications companies to essentially give up our data.
Data, great.
I had a moment of panic and I was like, what's this got to do with the pandemic? On further reflection, I realized that, you know, for the purpose of knowing who has been called by whom, it is not unrelated, let me put it that way, that knowing who the people, the confirmed cases have been in contact with might be useful, as the EI said, for contact tracing and all of that. Nevertheless, it did give me great pause to consider that to trace the contacts of the cases, now everybody's private data, who they've talked to, what they've talked about, how they feel about very personal things, how they feel about politically sensitive things. This is all stuff that the executive now has access to. And we do not imply mala fides, bad faith in our government when we worry about what our government knows about our private thoughts. When we do that, we are only acknowledging that we realize that they're human, and even when someone you don't think well of insults you behind your back and you find out about it, you have a little bit of a negative reaction to that person after that. So the idea that all of our private conversations are now open to the state as and when it chooses to look at is very concerning. So I can't say that the president had no use for the EI. I can say that I'm not very comfortable knowing that this EI exists and affects me.
Right.
And I can't say that no other president will use it because the power exists under the act. And maybe this president will only ever use it for COVID-related things. What about if we had a president like Trump who might decide that political opponents don't deserve state help? You know, and what if we had a president who decided that he would find out who was talking about not voting for him before the elections to decide what will happen to them? And we have a history that we should be very careful about repeating. We have a long history of arbitrary power. We have a long history of executive overreaching. What that has, that's not just a historical fact, because it has an effect on the people's psyche as well. What it means is that as a people, we are a little more tolerant of strong executives because we've been raised as such. So when our constitution gives us protections against strong executives, we should be very hesitant to give them up because we're not quite in the place where we are able to personally note when, as people, to note when our executive is overreaching. And historically, executives don't come and announce, I'm going to issue this EI so that I can punish my opponents. They tend to find a good reason. So when the people are accustomed to interrogating the executive, the motives behind the public motives can be reached. And that may be, in those cases, it may be okay to give them some strong powers. But when you have a people like us who are so used to overpowerful executives and who have a cultural deference to authority, it's bothersome that we have given these powers in perpetuity. If the Act even had a sunset clause like Article 31 does, I may be a little less opposed to it. But this is it. The president of 2089 could use Act 1012 if it's not repealed. And the incentive for a sitting government to repeal an act like that is very low. It's very low. Executive power by its nature wants to act and wants to act fast and wants to act without being contradicted. So it's unlikely that anybody will win power and come into office and say, hey, let's roll back my ability to move. And for me, that the big concern there was, even with all of its vagaries, if it had said for the duration of the pandemic alone, it would have been a little less scary.
Right. But let me come back to Dr. Tupper. I think we have him in our midst. Oh, can you hear me? Dr. Tupper?
Yeah, I can hear you.
Please let me take you before I lose you again. What are your thoughts on the implications of the executive powers for human rights, with particular focus on EI 63 and Section 76 of the Electronic Communications Act?
The law enforcement grafting law enforcement or national security issues into this pandemic is the most dangerous thing to think about. You will appreciate that.
Hello, Doc. Dr. Tupari.
And if you look at Article 21, it is actually about the most important thing there's a first, yeah?
Yes.
Are you there?
Yes, we can hear you. Please go on.
Okay. The only thing that comes to mind, so far as Article 21 is concerned, for purposes of this EI, is about free speech, expression, information, and what have you. Privacy, the right to privacy, is not under Article 21. The right to privacy is actually under Article 18. So it means that Article 18 has been moved into Article 21 for purposes of this EI. And you will think that if you are derogating in situations like this, derogation in my understanding has about two elements. We depart from the regular law, and then we'll provide a justification for that departure. I am not sure whether we can provide a justification for this departure if you rely on Article 21 alone to invade people's right to privacy, so far as Article 18 is concerned. It's not under that regime. So that's why I was saying earlier on that you will see that the Restriction Act adopted almost all the provisions under the emergency provision. And then the powers that were assigned to the legislature are now being assigned to the executive. And then the executive is all over, affecting certain rights which are not under the Article 21 regime. So it is actually difficult to make a justification on the plain words. So the second element of derogation is going to be problematic. And remember, in circumstances like this, derogation is not cancellation. Derogation is not abrogation. Emergency situations are not meant to abrogate rights. Emergency situation may present two forms: that there's a constitution and there are constitutional norms. We may have certain things that will affect the constitutional norms in order to have the constitution itself being in place. Can we provide a justification for this? We make references to the provisions that we have relied upon. I don't think so. Article 21 does not speak to privacy. So this horizontal legislation, which actually defines the logic of science of legislation, is a potential threat to people's rights to privacy.
Right. Thank you. I see that we have Professor Lumumba joining us. Prof, welcome to the seminar. Prof Lumumba. Right. I think our organizers will help us to get through to Prof in a second. I think it's now connecting to audio. Quickly, let me come back to Prof Prempe and Kwashiga on the implications these executive powers have on human rights.
Yeah, so I think when you normalize emergency powers the way we have done by ordinary legislation, not in conformance with Article 31, what you do is that you essentially treat as ordinary and as unexceptional situations and moments that the Constitution would have us treat as exceptional moments, right? And so going forward, we are going to see a normalization of this kind of emergency regime. As we've said, Act 1012 is not COVID-19 specific, which means it continues, it has no set duration. Any president in the future can resort to it to address whatever emergency that comes to mind. So that is one problem. Now, if the president had proceeded under Article 31, in other words, even if this were deemed as we were in a war situation, right? Under Clause 10 of Article 31, you would notice that only those measures that are reasonably justifiable for the purpose of dealing with the situation that exists during that period are permissible. So it is not this blanket thing that you could do, anything that you want. Article 31 actually has limits. There has to be a very close nexus between the measure that you are taking and the situation that you are trying to address. And that particular connection between the reasonableness of the relationship between the measure you've taken and the situation you are trying to address is judicially reviewable, right? So here you are, we have a number of measures that have been taken. I agree, many of them seem relevant to dealing with the particular contagion, the particular epidemic that we have now. Some of them, especially the ones dealing with interception of electronic communication and the like, overreach clearly, right? Because they are not narrowly tailored to meet the particular threat that is posed by, so we want, for example, to see who has contracted the virus, who have they been in contact with, and those kinds of things. If the kinds of interception and the kinds of surveillance, electronic surveillance, that's permissible under this Electronic Act thing, would be limited to finding those kinds of contacts for the purpose of tracking the spread of the disease, that would be the kind of nexus that we would be looking for. But this is a fairly broad, overreaching kind of law that is, again, not COVID-19 specific, right? So this is the nature of the complaint. Now, the other one, Mami has spoken eloquently about the issue being not really mainly about the measures or a disagreement over measures. It's mostly one over methodology, but there's also disagreement over consequences, and where the human rights stuff comes. If you have proceeded under Article 31, under Article 32, there is a long list of procedural protections and safeguards that people who are detained under the state of emergency provision would actually be granted by the Constitution. So if you were detained, Article 32 says, where a person is restricted or detained by virtue of a law made pursuant to a state of emergency, the following provisions are applied. Your family must be told about your whereabouts. The minister must give periodic account of all the persons who have been detained, their names, their whereabouts to Parliament, published in a gazette. None of this is available now. And even where there are criminal penalties under a state of emergency, all of those lapse upon the duration of the emergency. Here you have situations where people have been put in jail already for 4 years. The emergency would lapse and they would still be in jail. Right? The emergency would lapse. This COVID-19 stuff would lapse, and those people are in jail for 4 years. If they were under a state of emergency, they would be out upon the expiration of the emergency, right? So there are a number of that government has chosen to be that's not compliant with Article 31 as opposed to proceeding under Article 31. So there are grave human rights concerns there. Have you lost me?
Hello, Prof. Prempe. Yes, we did briefly. Yes, please wrap it up. Yes, we lost you.
Yes. So I mean, I think the point I'm making is that because of how we have chosen to proceed, a number of safeguards and protections that would otherwise those persons detained, right, arrested and detained under who would have been arrested and detained under a state of emergency no longer are available as protections or safeguards for those who are currently arrested and prosecuted. No concerns there. And again, we've already made the point about the fact that we have chosen to proceed under a law or two laws, in this case, that are not COVID-19 specific and that are not narrowly tailored to address the particular COVID-19 situation that we have. You know, they go way beyond COVID-19, not only in terms of time, in terms of duration, but also in terms of scope. And yet the president does have the power to do all those things.
Right. I think yes, thank you, Prof. We lost you just about the time you made your final statement. Finally, I'll come to Prof. Kwasiga. I think we have Professor Lumumba with us. Prof, welcome to the seminar.
Thank you very much. I've come a little late, so I'll be handicapped in terms of my contribution. But I'm here listening. Yeah.
We're happy to have you here nonetheless. Prof, I'll come back to you shortly to give us some perspective from Kenya. Prof. Kwasiga, there's the same question on human rights, but perhaps let me frame this question in this way. And flowing from one of our participants, says, how different is the imposition of the Restrictions Act from the Preventive Detention Act of 1958? I mean, answer this generally on the powers exercised by the executive under the Act on Fundamental Human Rights, but we focus on the historical PDA.
Definitely, you cannot compare the PDA situation to what we have now.
Right.
The situation was a completely different situation. You are arrested and detained for 5 years, even renewable for another 5 years without trial. No assessment.
Right.
We, under the current situation, we have the courts sitting. The powers of the courts are, you can go to court today and if you challenge this law, that is the Imposition of Restrictions Act. And indeed, one of my colleagues, Dr. Bassett, wrote a paper in which he even argued, and I agree with him, that because Parliament did not give specific powers to the president, because Parliament gave those wide powers to the president, and because Parliament had abdicated its powers, the powers to specifically legislate, I argue, and I agree with him, that all the actions taken by the president so far, particularly the incarceration of those who breached the directives, who are in prison for 4 years upwards, would be unconstitutional. Our courts are in place, and anyone who wants to go can go. Something that you may have a difficulty doing under the 31 situation. So you cannot compare current situation to Preventive Detention Act. You can go to court and challenge this act, and I dare say that you can challenge it successfully because Parliament has failed to do what it must do. Thank you.
Prof. Lumumba, let me come to you now. So so far we've been discussing the nature of emergency powers that have been exercised by the executive branch of Ghana, and what the impact of those powers have been on human rights. Are you able to share with us a perspective from Kenya? What has been the executive powers exercised so far to deal with the pandemic? And in your opinion, there any areas of concern in respect of fundamental human rights?
Let me say that I've had the advantage of listening to the conversation around your Article 31. And I've also had the advantage of reading that particular provision of your constitution. And I've had the interventions of the other panelists as to whether that is the route that ought to have been taken as against the enactment of a piece of legislation that responds to the situation as it is. And I've had it being argued, at least I can be corrected if I'm wrong, that there is a sense in which the piece of legislation, which is sui generis as regards COVID without naming COVID, is one that lends itself to abuse in the future. But in my understanding, if only I'm to take a different view, is that there is the danger in times such as this to be very pedantic in our interpretation of the Constitution. And when you are pedantic, you lose the politicians who are dealing with a practical situation.
Right.
But that said, let me speak to the Kenyan situation. The equivalent of Article 31 is Article 58 of our Constitution of 2010. And typically, these provisions relating to emergency are not very far from each other, complete with derogation and kindred provisions. But what the Kenyan government has done, which has been informed by the, one may say that the transient nature of COVID, is to resort to the Public Health Act. So that if you look at the provisions that have been dealt with, the orders that have been issued by the president and the various orders that have been issued by ministers, they are invoking the provisions of the Public Health Act, whether it relates to movement of persons, whether it relates to confinement of persons, because the Public Health Act in Kenya is very robust, because it does contemplate emergency situations such as these. And that is the piece of legislation that has been used to good effect, in my view, in terms of limiting power. And whenever it was necessary to impose a curfew, it is the Public Order Act that has been utilized, and the minister has then given instructions and directives which have been gazetted to that effect. And this particular issue has been litigated in our Kenyan courts. When the police were deemed to be using excessive force in enforcing the curfew order, an application was made by the Law Society of Kenya, and the court made a finding that human rights are not suspended in an emergency situation. So in a nutshell, what has happened is that the Kenyan government has not invoked your classical emergency powers. They have used existing legislation as the avenue via which you address these specific issues. And my last point is that perhaps that is the avenue. It is the avenue because it is the problem we have is a transient one. And because of its nature, there is a sense in which when you talk about the advice, and I heard my good friends talking about when you are taking guidance or seeking advice, from whom do you seek it? In this particular pandemic, we are responding to the directives issued by the World Health Organization. And to the extent that the public health does acknowledge the role played by bodies such as these, you can then appreciate that the Public Health Act has provided a very good avenue of dealing with COVID without invoking the emergency powers.
Right. Right, thank you. For Dr. Tupari. Right, let me come back to you. How do we check the possible abuse of executive powers during this pandemic, particularly with respect to fundamental human rights? I know you have made clearly the point that even with the invasion of privacy, the Constitution, the EI 63 goes beyond its mandate to invade the privacy of citizens. But the right to privacy aside, how do we check, or how do we balance the need to restore and ensure fundamental human rights as against the exercise of emergency powers during this pandemic?
First of all, the law enforcement has a matter of legal design.
I think
that has been adopted. You will realize that as a matter of design, the focus is more or less like a law enforcement kind of thing. Let's deal with them. Let's ensure that they comply. So the citizens have realized that there is a likelihood that citizens would evade public health workers in dealing with this issue. That is, if you make it a law enforcement issue, let's get to the streets, let's get them out and things like that. So most importantly, the
I'm afraid, Doc, we continue to
conception should have been this, and would have been how we deal with that kind of pandemic instead of It is a network issue.
Yes, that we are having some serious network issues. Prof. Prempeh, let me come to you with this same question. How do we check? I know you are of the position that we
how do we
triggered Article 31. But that nonetheless, we are stuck with the imposition of restriction act. How do we balance the need to ensure fundamental rights, freedoms, and rights as against the need to protect public health in the midst of this pandemic? How do we check possible abuse of executive power during this period?
Sorry, I'm not. I hear you.
I think we're having network challenges with Prof. Prempeh as well.
You hear the question?
Hello, Prof. Prempeh. Mami, let me come to you with the same question. Do you have any thoughts on how to balance the need to exercise some executive powers to control the pandemic and the imperativeness of ensuring fundamental human rights and freedoms?
As Professor Prempeh said, I think it was Professor Kwashika who said, our only recourse now is judicial review, because
right.
By the nature of the act, there's no avenue for direct engagement. You have to go through the Supreme Court. It's an effective remedy in some cases, and we have such a rich jurisprudence of human rights being protected by the Supreme Court that it's some comfort. The only problem with judicial review is there's always ex post facto. So though it is some check, it is a check that happens only after some violation has already occurred. It takes some time. Even those cases where the court gave its order before giving its reasons at a later date, it was not a 3-hour or even 3-day process. So although it does offer us some avenue, I'm not sure that it goes far enough given the scope of power that we would be checking by review. But it is our only option at this point, unless Parliament decides to re-engage with the Act and revise it.
Right, Prof. Kwashiga, your thoughts on that question, please.
Yes, I have said it several times that this act can be challenged because it gives too wide power to the president.
Right.
Powers that Parliament should have exercised. Parliament has, as it were, abdicated its functions to the president, which is not permitted. So I think any challenge to the act will be in place.
Right. Prof. Lumumba.
Okay, Doc, is my network okay?
I can hear you for now. Yes, please go ahead. Dr. Tupari,
Yes, I was just going to say simply, I was just going to say simply that inherent in that provision is a legal test that can be exploited at the court, because the test is that measures that are reasonably required. And as I told you, the definition of the president should not be taken as sacrosanct. It should not be taken as being a definition that precludes all definitions, or should be a definition that should not be challenged or that cannot be interrogated at the appropriate forum. Number two, the courts are not suspended so far as this is concerned. So it even provides a window that though we castigate or criticize the wide powers that have been conferred on the president, in this case the executive, so far as the institution is concerned, it also provides us with a window that citizens can still play a role in dealing with the rule of law issues. So it shouldn't be looked as if the doors of rule of law, enforcement of the Constitution and its values are closed because we have an EI or an act of parliament that has given wide powers to the president. Remember, even if you are dealing with what do we call it, the Article 31 issue, which is emergency powers, it actually is not a give somebody the power to examine maybe questions, reasons that are provided, or even the measures that are given by the executive to ensure that they are within the context or they are contemplated by the spirit of the Constitution, who defines them.
I think we lost that.
In this case, that we just look at the face of the provisions and say that they are enough, or whatever reasons that are coming from the president are enough, and therefore they cannot be reviewed. We should take that as sacrosanct and we should go with it. It will not be appropriate for us. So the role that citizens
Right, Prof. Lumumba, let me come back to you.
That has been assigned. Even the framework, the legislative framework itself is what the Constitution contemplates.
Dr. Tupa, I think the challenge with the network persists. So I'll move on to Professor Lumumba. Prof, how do we check possible abuse of executive power to ensure the required respect for fundamental human rights and freedoms during the pandemic?
First, let me say that my understanding of the piece of legislation, which I've not had the advantage of reading, is that it is designed to confer powers which are necessary during the period when the pandemic exists. If that is the understanding of it, and if that piece of legislation was enacted specifically to address that issue, whatever powers are conferred on the executive cannot, by any dint of interpretation, be deemed to be plenary in nature. And if we accept that those powers are not plenary in nature, and we accept that by parity of reasoning, those powers are comparable to a certain extent to the powers that are conferred under the provisions relating to emergency, and agree further that this route was taken because it was not the desire of the executive to have constant scrutiny and possible delay of the legislators. In our understanding of the interpretation and application of those powers, we must agree that the test prescribed in the Constitution is still alive and well. And if that test and those tests are alive and well, then our fears are misplaced. Why do I say that our fears are misplaced? The Constitution is quite explicit as to what rights, if any, are derogable. And even if they are not derogable, the exercise of powers which are conferred by statute must be exercised only to the extent that they are necessary to deal with the pandemic. If that be the case, then the courts confronted with a real issue arising out of a complaint that is generated by the exercise of powers under that piece of legislation would find it very easy to find that those powers offend the Constitution. And if they offend the Constitution, they would strike down whatever action has been taken. And if the application is ex post facto, as we have been told in terms of a judicial review, then compensation would follow a finding in favor of a litigant. That is how I would want to look at it. So in a nutshell, I'm saying these powers are not plenary. These powers are conferred for the purpose of dealing with a specific emergency. And therefore, in interpreting those powers, we still remain with the constitutional test. And the constitutional test is as clear as it is enforceable. And to that extent, therefore, our fears are without basis.
Right, thank you, Prof. Mami, let me come back to you on this question. What are your thoughts on the EI 64, which in a way disallows or does not enable Ghanaians who are stuck abroad to return home?
The particular provision of that EI is a source of great worry for me, because the most fundamental right of citizenship is to be in the country. That is the most basic right. It's the one place on the planet that you have a right at any point in time to be in. And I understand the pandemic has caused concerns about what we're bringing in when we come in. Nevertheless, we do have a very basic right to be here. And it's not just a pedantic concern. So consider a Ghanaian who went abroad for a function, who went on a 6-month visa, who is stuck there because the borders to Ghana are closed, and now by the operation of their own state, they are a criminal in somebody else's country. To me, it's a big concern. We did do some mandatory quarantining, and I understand that it's expensive. And so there may be concerns about the cost involved. But for the state of Ghana to make a Ghanaian a criminal in another country, I think that at its core, that makes you wonder why you should be a Ghanaian then. So I think the restriction of the movement into Ghana by non-citizens, if you look at the act itself, it specifically says entry into Ghana of persons who are not citizens. If you look in the Constitution, all of the movement restriction options say persons who are not citizens. The right to be in Ghana, when you are in Ghana, the executive has the right to restrict where in Ghana you can go in an emergency. But for you to not be allowed into the country at all, for me, that's a very big worry. If you are stuck abroad and you're out of money, and your country says you can't come home, but you're stuck in somebody else's country, you're out of money, you're on the streets because you can't come home. It may seem a bit far-fetched, it may seem that people, but not everybody who goes abroad has a permanent residence there or a place to be indefinitely there, or financial supplies to indefinitely continue in existence there. So I think if there's one thing I would ask the government to really reconsider, it's the restriction of entry into Ghana by citizens abroad.
Prof Lumumba, let me come back to you. Do you have any thoughts to share on that particular issue? Perhaps.
No, my position on that is very clear, and I can't agree with her more. Wherever your citizens are, there is no piece of legislation by whatever definition, by whatever justification, that can say that I, as a Ghanaian who was caught up in Kenya or in China or any other part of the world, would be denied entry into Ghana. The law must allow me to get into Ghana, and if for any public health reasons I ought to be quarantined, then I ought to be quarantined at the state's costs. If the state takes care of prisoners, how much more are citizens who are simply victims of circumstances in a situation such as this? So if there is a provision of that kind, then the president ought to be told in no uncertain terms, he happens to be a lawyer, that is a rogue provision that has no business being in any piece of legislation.
Right. Let me find out from other panel members if there are any differing views on that. If there are no differing views, then we can move on to other questions. Prof. Prempe, Prof. Kashiga, are there any?
I agree with those views.
You agree with those views? Yes, Prof. Prempe.
Sorry.
I agree. I mean, if somebody is stuck, they must be stuck for reasons unrelated to a law in their country that denies them entry back into the country. I mean, it must be because the airlines are not flying, not because my country will get me back into the country. There shouldn't be any such.
Right.
I think we must have some cautionary rules so far as that point is concerned, because human rights, we will defend them, but human rights always have a point that they are not absolute accept others. And of course, there's always a balancing test that one must strike when you have competing rights or you have competing values and what have you. So it is not just a general justification of argument that we will make. It is a specific argument as it pertains to the situation that we have at hand. If it's an issue, as you said, that they are saying that don't come back, that can be problematic. If it's an issue that even where you are unable to leave, then the situation changes. Whether or not Ghana should be able to get them back to this country is a different thing. So if we explore the arguments and see if it is just that we close the borders and that's why they are unable to come, I think that we may not be attending to the peculiar facts of all the countries that are involved so far as closure of borders are concerned.
Right, thank you, Dr. Todd. That was clear. We could hear you very clearly. Now, to all the panelists, I'll come to each one of you. How do we roll back some of these executive powers after COVID-19? Now, the concern has been raised that there appears to be no expiration date for some of the powers that may be exercised. Are these concerns justified? How do we roll back some of them? Let me start with Professor Prempeh.
Yeah, I think this is one of among the reasons why some of us definitely would that we proceed in these.
I think we're losing Prof. Prempeh as well. Prof. Kwashiga.
Article 31 just bounces back. I mean, basically, it's a time limited. And once the emergency passes, then basically the bounce back normal, the substance.
Prof. Prempeh, we're unable to hear you very well. So if I may move to Prof. Kwashiga, and when your network bounces, then I'll come back to you on that question. Prof. Kwashiga.
Yeah, you see, if you look at, for instance, Article 21(4)(c),
right.
it says that the imposition of restrictions that are reasonably required in the interest of defense, public safety, public health, etc. Inherent in that is there are limitations. It doesn't mean that you can just make a blanket law for all time, restricting the rights herein provided for. You can, at an appropriate time, these laws can be challenged. In fact, if you look at Section 2, this Section 2, let me see. Yeah, Section 4 of the imposition of restrictions, that says duration of restriction. A restriction, with your permission, for a restriction imposed under subsection 1 of section 2 shall be for a period of not more than 3 months.
Right.
Then it goes on, despite subsection, in other words, I don't want to take too much time. In other words, it may seem to be open-ended, but inherent in that, I have the strong belief that this can be challenged when the situation is no longer there. It cannot just be there forever, because we have a constitution that provides for things to be done under certain circumstances. When those circumstances are gone, I think we have a Supreme Court that should be very discerning enough to know what to do if the time comes. Thank you.
Right. Thank you, Prof. And finally, Professor Lumumba, on that point.
I think the law, thank you very much. I think there is a lot of decisions across the world which are very explicit in saying that when a piece of legislation is enacted to address a specific issue, if that piece of legislation does not have a sunset clause, then immediately the situation it was meant to address disappears. That legislation must also, but of course it will not do automatically, but then it gives us an opportunity, if the parliament does not repeal it, a court of law can, upon application, declare that particular piece of legislation to be one that is without effect, and then it will stand repealed. And that, I think, is the right approach. So the absence of a sunset clause or a time within which it shall be deemed to be of no effect, notwithstanding, there are avenues that can be used to strike it down.
Thank you, Prof. Finally, Prof. Pepper, I think you're back on. What are your thoughts on how do we roll back some of these executive powers post-COVID-19?
I think I return to an earlier point I made that when you proceed to grant emergency powers the way we have done, you basically normalize.
Right.
You know? And historically, when you look at the growth of executive power, emergencies have always grown grown executive power. You go back to even the US, right? The framers of the United States Constitution did not think the president would be the most powerful office in the country. They thought actually of the three Congress was going to be the most troublesome. They were more worried about and proportionally more powerful than the Congress. And a lot of that has to do with emergencies, with civil war, with foreign wars and others that have always given the president more power. And when those emergencies have lapsed, powers have never really fully bounced. So there's always been this which those who look at emergency powers approach it with caution, that historically, this is what we have seen. You grant power during an emergency, the emergency lapses, and there is a good bit of that power, residual power, still in the hands of the executive, or we become culturally used to very elastic executive powers, and then we begin to submit to a regime of that sort. So there is worry. Some of these powers will remain even after the emergency has passed, and especially in our situation where there are laws that have nothing to do with an emergency as such, not the current one. Those laws still remain in the books. This law remains on the books after COVID passes. The Electronic Act stuff has nothing to do with COVID. So we are still in this regime where we have laws that are part of our regular body of law that were just used in COVID, and after COVID will come back, remain on the statute books as part of our regular body of law. For what purpose? To be used again on the say-so determination of a president in some future time. So that is my worry with making a special piece of legislation that does not specifically, however, address this crisis exclusively and leaves it on the statute books for much longer than the crisis requires. If we had a particular law that only dealt with this now, the Emergency Act, for example, if we had invoked it, or if we had even amended the Public Health Act and substituted the president for the minister, right? Maybe we would be a different situation now. But I worry that there will be some residual from this period that will lead to more accretion of executive power even when the emergency passes.
Right.
It's the lesson of history, actually.
Thank you very much, Prof. Prempeh. The organizers have just hinted me there are a few participants that they would like to take on video to ask questions. Mausi, yes, can we have our participants kindly briefly introduce yourself and then shoot your question?
Hello, good afternoon. This is someone that I'm a
yes.
participant. I enjoyed the exchange between Mami and Dr. Safari as well as Paul. I want to ask, would
the volume should go up. I think we cannot hear you well.
Okay, hold on a minute.
Perhaps you use
Can you hear me now?
microphone close to.
Can you hear me now?
Yeah.
Yes, we can.
Yes,
Yes.
Yeah, I'm saying that based on the discussion between Mami and Atupari and the dichotomy between Article 21 and Article 31, and the examples cited by Prof. Lumumba and Atupari on how Nigeria and Kenya have treated it, would our route have been better if we had gone under the Public Health Act rather, which gives the minister certain powers in handling various diseases that affect Ghanaians, rather than going through Article 21 route, which affects our human rights provisions that we are contemplating about?
Right. Any of our panelists to begin? Take it.
Yes. This question. Yes, I will agree with him that perhaps if we had gone under that provision, it could have been perhaps even better. Because if you look at Article 14 plus 1D of our Constitution, a person suffering from an infectious or contagious disease to be taken care of, to be quarantined, and the Public Order Act, as I stated earlier on, has provisions that permits the minister in this case to take certain measures to control the situation, including quarantining, ordering people to do this or that. So it could have been a very appropriate law to use.
If I can respond quickly,
Yes,
I was skimming through a PhD thesis by Ishmael Norman for the University of Ghana's Public Health on Ghana's preparedness for public health disasters. It's a 2009 thesis. And he made a point that I thought was actually very valid, that we have very many legislations that deal with public health emergencies, but they are such that some are restricted to specific fields, some overlap with others, so that there's a lack of a coordinated response legally towards public health crisis. So I guess I would say that while it might have been possible to go that way, we have such a disaggregated total regime on public health that perhaps it was required that we find a single legislative point from which to operate in this pandemic time, and then to review the existing legislation, whether it should have been Article 31 or the Imposition of Restrictions Act is the debate. But I do think that not relying solely on the Public Health Act was not a bad decision, given how many different pieces of legislation are about disaster and emergency management, and without a coordinating point.
Right. Thank you. I think we have another participant who would like to ask a question via video. Let's to Alenga. We're ready for you.
Yes. Yeah, hello, can you hear me?
Yes, Cletus, I can hear you.
Yes, this is a straight question to Prof. Prempeh. His criticism seems to be targeted only at how Act 1012 is drafted. Now, my question to him is, now, will he rather wish that Act 1020 was well drafted to give Parliament some powers, some oversight powers, and to ensure there are checks and balances? Or would he rather wish that he invoked the Article 31 powers? In other words, if there is a way of rather amending or redrafting Act 1020 to deal with the circumstances, would that not be better than always invoking the powers under Article 31 under such circumstances? That's my question. Thank you.
Thank you, Cletus. I think perhaps as a follow-up, I saw a question regarding the nature of the pandemic, being that social distancing is actually recommended, and how our Parliament will have to be frequently be invited to, either extend the powers of the president. you think the nature of how our parliament sits would have been problematic if Article 31 was invoked? And why not seek to have a better drafted parliamentary act?
Well, I think, you know, the framework of the Constitution shows the kind of framework or regime under Article 31 for good reason, right? So they have both political checks on the executive power and judicial checks remaining, right? And I think we as lawyers tend to
We're
there is a picture, right? So I'm saying, okay. Is it better now? Is it better?
It's better now, Prof. Yes.
Okay. So I'm saying that when you have a regime of checks and balances that includes Parliament staying in the picture with the president and periodically reviewing what measures have been taken in an emergency, and you decide to take Parliament out of the picture, just leaving judicial review, something happens. There's something, you have unbalanced the equation. There's a reason why judicial review was not left alone as the only recourse one must have in a situation like this. So I think we, especially we as lawyers, should take political checks as seriously as we do judicial review. It's not as if judicial review automatically operates as a check. Oftentimes, courts defer to presidents in emergencies all the time, right? So we have to be very cautious with quickly dismissing the kind of delicate balance that has been installed under Article 31 and thinking that, oh, as long as there's judicial review, that is fine, that is good enough. Judicial review oftentimes actually goes in the favor of the executive, not in the favor of the person making the challenge. So I think that's one point. Now, so my problem with article, with the Imposition of Restrictions Act, it's not just how it is enacted, but how it is enacted also is a problem. So here you have a law that takes the limitation clause that is attached to the Bill of Rights provision chapter in the Constitution and uses the fact that the limitation clause allows, under certain circumstances, rights to be limited, has now been taken as the source of power to then enact a law limiting the rights itself, right? I mean, it's a very weird use of limitation clause. I mean, the fact that you are actually using a limitation clause that is about restrictions on what the way powers can and cannot be used, right, has now become a source of authority for enacting. But maybe that's, too technical a constitutional argument. I think that the notion we are trying to promote here, that somehow recourse to Article 31 would have been too casual, is always going to Article. We have never used, Article 31, it's not an always kind of provision. You go there very rarely. A pandemic of this kind is rare. It's a once-in-a-lifetime event. Massive natural disaster in Ghana is rare. War is rare. These are the things that Article 31 was designed for. And if we used it this one time to address a pandemic, a global epidemic, I do not think that we would have trivialized it so that you could say that, oh, Article 31 is so special that we may not use it now. But when do we use it? When there's a cholera outbreak or something? I mean, don't forget that Article 1012, Imposition of Restrictions Act, has now essentially replaced the Emergency Act, because war is even, the president invoke it in wartime as well. So we have essentially created a parallel process that I believe politically will displace the Emergency Act as well as Article 31 itself. It really will displace it, and that becomes there's every political incentive, as we said before, for a president to resort to this particular law in the future rather than to Article 31, regardless of the circumstance, whether it's natural disaster, because all of them are now included under this Imposition of Restrictions Act. So it's a bizarre way to do things. if you have a law on the books, Public Health Act, that you think was somewhat insufficient, you could have amended it. I agree with this fact that you have this interagency approach to dealing with this problem. So if you thought that you needed to actually consolidate law, maybe we could have done that. We could have made the president the one in charge instead of the Minister for Health, if the president wanted to be seen as commanding this kind of stuff. So these could have been done. And I don't think that we had sufficient statutory armory already on the books for us to have gone this, to have fought this thing without going to create new law. And that was why people are suspicious. What are the intentions behind this new law when in fact you have enough armory? You could have amended, simple amendment, legislative amendment would have dealt with this problem. Why create this whole new bizarre law that doesn't seem to be COVID-19 specific, that doesn't, just lapse when this thing is over, and that is more draconian in the kinds of penalties it imposes on people than even a state of emergency under war would impose on late, the proclamation. So all of these are part of the reason why I think this is problematic. It's not just the way it is drafted as a technical matter. It's not just a matter of technical drafting. It's just the thinking behind it. I find a bit difficult to reconcile with the constitutional framework.
Thank you. I think the point has been made very clearly. And we have finally Jamel Dean Tonzwa with us. Jamel.
I'm trying to unmute.
Yes, Jamal.
Right. Okay, thank you. I'll direct my question to Professor Prempeh and then Professor Lumumba. I'm thinking that one of the lessons that COVID has taught us is that we can activate certain processes or there's a potential to activate certain constitutional processes, executive powers for national development. And I'm speaking specifically to Article 210, where the president can activate the provision to engage armed forces for developmental purposes. So my question is Article 210 envisaging situations where developmental needs, national developmental needs would relate to security matters, or we can use those executive powers generally for national development? In my view, the military has certain capabilities and capacities, for instance, engineering, and we know that right now they're working on some facilities in Pram and other areas, and they can construct roads and other things. And there are health capabilities too, and these are critical resources for national development. So the question is, beyond COVID, can we use this executive power and direct it towards national development?
Thank you, Jamal. Dr. Tupari, can we come to you on that? Do we have Dr. Tupari with us? Right. I mean, would you like to respond to this question by Jamal? I think we've lost Dr. Tupari. Yes.
The army is, it has capabilities, that is true, but it is an armed forces for a reason and not simply our task force for developmental projects. So I would hesitate to say, yes, every developmental project unleash the army. Part of their training is to give them an ability to be brutal, because they're trained for war, they're trained for security, they're trained for defense, and yes, they're doing amazing things in other fields, but let's keep our eye on what their core purpose is. Right. And when necessary, by all means, let us use them to do projects that they are suited to. But as HKP was saying about normalizing the use of emergency powers, let's also be careful about normalizing the use of emergency services. Because today they come to build something in a pandemic, we all understand, and then we start using them as a regular task force. And before you know it, they're building the president's house or farming on the president's farm. Because using exceptional situations in normal ways makes it normal to do so. And the people then accept it. And then, you have this erosion of boundaries. So I am very happy that our army is so multi-talented and we can rely on them whenever we need them. But let's be careful about defining when we need them.
Right. Thank you. I think I will take this last question and see the opinion, the thoughts of all our panel members. What role can regional bodies like ECOWAS and the African Union play to ensure that the gains of democratization and good governance will not be rolled back post-COVID-19? What are the roles, if any, of ECOWAS and African Union and other regional bodies in this whole discussion of democratization and good governance? Let me start with Prof. Lumumba.
Before I answer that question, let me advert to the question about the normalization of emergency powers. And I want to associate myself with the view that have been expressed by the two professors, that emergency powers are to be invoked and resorted to when there are clear emergency situations. The reason why we have Public Health Act and Public Health Act is because within those pieces of legislation, public emergencies of this nature, which are defined as epidemics or pandemics, can be dealt with. I've already given the Kenyan situation where we have not invoked emergency powers. What we have done is to make regulations under the Public Health Act. And even when it comes to restrictions, those restrictions are under the Public Order Act, and they are very specific that they are designed to operate during a defined period. And I can't agree more that when you begin to normalize emergency powers during peacetime, then there is the danger that you erode parliamentary participation, and then of course you energize the executive to have a greater appetite for these powers because they are very draconian, they are very efficient, they can appear to be very efficient, but they can also erode human rights. Back to the question about the regional powers, I think there is something that has happened. And all of us have attended the meetings or listened to the meetings that have been held under the aegis of ECOWAS or SADC or the East African Community or the African Development Bank as a specialized institution, and indeed under the African Union. One assumes that going forward, there will be greater coordination. Because what I've seen is that these meetings have been very pro forma firefighting. Perhaps there is a need to firefight, but very pro forma, and they lack the depth. And that is why you see that even within the West African region, if you want to examine the coordination of the various governments in the region, whether it's Ghana, Nigeria, Togo, Liberia, Sierra Leone, you don't see it. And the same is true. I was listening to the Ugandan president yesterday, and he was saying tongue in cheek that if you look at East Africa, Uganda is the bedroom, Kenya and Tanzania are the sitting room. And if we are doing our little thing in the sitting in the bedroom, assuming that we will not go into the sitting room, then we are deluding themselves. So post-corona, one must ask critical questions. How do we coordinate a lot more intimately in matters such as these? Perhaps it would appear we did not learn from Ebola, which was an epidemic, never declared a pandemic in the manner that COVID has been. So going forward, it will be necessary to look at these institutions and their modus operandi in a totally different way if they are to contribute positively to the well-being of the citizens of those regions.
Right, thank you. Prof. Kwashiga, please.
Yes, thank you very much. I don't see what much the ECOWAS or African Union can do. It's not like the European Union, which is now engaging the Hungarian Prime Minister seriously over this use of emergency powers. Perhaps if this is my final, with your permission, what I would want to leave with Ghanaians, and therefore political elite of Ghana, is to draw our attention to Article 36 Clause 2E of the Constitution,
Right.
which is a lesson to all that laws have their limits. And we see it all over the place. In fact, 36(2)E says that the most secure democracy is the one that assures the basic necessities of life for its people. That is what we have in our Constitution.
Right.
You don't need draconian laws to deal with situations. A time will come when even those laws, no matter how harsh, will not work. So COVID has come to tell us that it is better to buy the hearts of the people with policies that will be to their welfare, as Article 1 of the Constitution requires, rather than trying to resort to just laws to force people to do what otherwise they will not want to do. Thank you.
Thank you, Prof. Kwesiga. Prof. Prempeh, any thoughts on the role of regional bodies like ECOWAS and AU?
Well, I think by definition, I mean, if this is a pandemic, then by definition, it is cross-border in nature, right? Even if you were successful in solving it within the borders of your country, unless you are actually going to keep yourself close to the world in perpetuity, then you would also be interested in how your neighbors were also resolving the problem, right? Because if you resolve it in Ghana and you get to 0 new cases and we're all fine, and Togo and Burkina Faso and Nigeria and Benin and Cote d'Ivoire and the rest of our neighbors are still experiencing the epidemic, then basically, unless we shut ourselves off forever, it will come back here. So regional solutions and regional approaches to the problem, in parallel, of course, with our national approaches, is, I think, imperative. Like, I understand, of course, the imperative of national governments basically trying to resolve this thing on their own, because their political accountability is to their people directly to find solutions. But I think at the same time, at least now that national governments have a certain handle on the problem domestically, we should create our regional resources, right? ECOWAS, SADC, EAC, AU, to really begin to look at, okay, so as countries manage to bring the situation under control, what do we do to prevent spread across the border and that kind of stuff? And the EC was very, and the EU was slow even in coming to this. They regret it now. They're actually trying to go back. And I think one of the things we should really learn, the lessons we should learn from this is that the absence of a coordinated global or at the very least regional approach to dealing with the problem is part of what we should learn not to do again. And I agree with Professor Lumumba that we ought to have learned lessons from Ebola, that in situations like this, national approaches alone do not suffice. So I think a regional approach to this, it doesn't have to come in the form of a law, obviously not law as such, but basically some regional coordination, some approaches to how to deal with this cross-border is very important. Otherwise, we risk a return of the virus, countries where they are still not being totally brought under control, to countries that have fortunately been successful in bringing them under control. Or otherwise, we shut ourselves from the world for, in perpetuity.
Thank you, Mami. Your views on the role of regional bodies like AU and ECOWAS.
I agree with Professor Prempeh and Professor Lumumba. It is not something that a country should say, I've got it, I'm done, good luck to you. And in the EU, where they have, I suppose, better border control, given how well they've been able to keep out immigrant Africans from the seas, they've had trouble. They are now working at more regional things. And on our part of the world, our borders have always been porous. We don't have a border wall from one end of the country to the other. That means we cannot at any point in time take the attitude that we're good and people next to us have a problem, because our traffic flows across borders fairly seamlessly. So we do have, going forward, the very important challenge of figuring out how, as a block, rather than as everybody in their room in a compound house, will figure out the future responses. The challenge I see, though, is that, as Professor Prempeh said, the accountability of a government is to its people. And in pandemics, the people turn to their leadership clamoring for signs of hope, leadership, alleviation, which makes the states more state-oriented in their approach. And then as they acquire more power, it becomes harder for the state to subordinate itself to wider groups. And we've seen this everywhere, that in the EU, when the COVID became a problem, you would hear Germany's response and Italy's response and the UK's response. It wasn't the EU as centrally as the EU has become in their lives that led the pandemic response. And in the beginning, you noticed some countries looking away as Italy suffered. But now we are all realizing that it's not something that anybody can look away from. So I do see that we will have to rethink the way our regional bodies have engaged. And I don't think ECOWAS on an average day means much to an average ECOWAS citizen. And it's going to have to do a little better if it's trying to coordinate our movement and our lifestyles. But it is going to have the challenge that is going to face states who have now remembered what it is like to be a strong state and almost absolute. And that balancing of giving up power in order to acquire regional coordination might be a difficult space to navigate going forward, but it's an absolutely necessary one.
Thank you. Dr. Tupari, do we still have you?
Yes, I'm here. I'm here.
Right. Perhaps I'll hear your thoughts on it, and if you could just wrap up with your concluding remark as well. I think Prof. Kashika did that, so I'll just come back to our three panelists. Your views on the role of regional bodies like AU, and your concluding remark on the topic. Thank you.
Okay, I think that we have witnessed or realized that there's some plurality of legal designs that have come out of African countries or even ECOWAS, so far as this pandemic is concerned. If you look at Togo, their legal response is dependent on their constitution. It is a country that has a provision on emergency powers. Burkina Faso, they don't have. Their 1991 constitution does not have any provision on emergency. Nigeria, they have, but they have not used it. They've used a Quarantine Act, which is 1928 Act, colonial days legislation. So you can tell, in Ghana, for instance, we have Article 31, we have not used it. We have an emergency act, which we have not used. We decided to rely on Article 21 of our constitution. So this plurality of legal design will tell you that whether this question is a political question or it's a constitutional question or it's a legal question becomes very difficult to determine. And you do not even have what you can term a regional definition of emergency, so far as this particular pandemic is concerned. So in the country, you do have difficulties even arriving at a consensus, whether this is the form of emergency that requires Article 21 or is the form of emergency that requires Article 31. We may engage in objective assessment or evaluation of this and things like that. So this lack of regional definition might lessen the potency of the regional body in terms of dealing with this pandemic as a group. But what you can expect them to do is that
I think we're looking to her again. I can understand the interest the topic has generated, but unfortunately, we'll have to wrap up. Can we have
the executive? So concluding remarks will be that.
Right, can we take concluding remarks from Mami? I'll start with you, and then Professor Lumumba, and finally Professor Prempeh. I think Professor Koshiga already gave us his concluding remarks, for which we are extremely grateful. Yes, Mami.
I think I'd like to conclude by noting that we have a democratic system is one in which the people have declared that they have confidence in a particular government to do a particular thing. So in the pandemic, we have, by our methodology of government, said we trust the current government to handle it. That said, we also reserve for ourselves certain rights in our constitution, and we expect that our government will not attempt to circumvent that methodology in fulfilling the mandate that we agree that they're good to fulfill. And I would say that the results notwithstanding, the ends do not always justify the means. In fact, they rarely do. The ends tend to corrupt, the means tend to corrupt the end. So as we are thinking through this very, very tricky situation that keeps developing and keeps changing, and we understand that our executive needs to be able to take some decisions, perhaps on the fly even. But if we are the beneficiaries of those decisions, and if we are the reason why the state is acting, then the state should act in the way that we have asked the state to act, and the state should protect our future as it is securing our present. And giving our executive the sort of rights that take us back to our arbitrary past is not what we should be doing. And I think if anybody has failed us in this time, it's Parliament. And Parliament has given itself an existential problem because it has shown us that it is not necessary. If our executive is able to handle this problem without any abuses, without any cause for concern, and is able to make us feel comfortable with them having that amount of power, then our Parliament has shown us that it's not a necessary institution, and perhaps we should scrap it. But because we know human nature, we realize that even meaning well, powerful people can make mistakes that are really far-reaching and should be slowed down sometimes in the process in which they make decisions. So Parliament should understand its role in a constitutional government and not throw up its hands, leave the executive to do whatever it wants, and then come and stand for election in 4 years.
Thank you. Prof. Lumumba, your final word.
Thank you very much. Let me start from where Mame stopped by saying that the means must always justify the end. If you allow it to be otherwise, then there is the danger in what Professor Prempe said, the danger of having an executive that becomes one that has a huge appetite for powers that make them rogue executives. So going forward, it is very important in pandemics such as these to ask ourselves, what avenues do we take? And in many countries, and Ghana is not so fundamentally different from Kenya or Zambia or Malawi in terms of the pieces of legislation we inherited, I believe that they are very useful avenues that can be utilized when you are dealing with emergencies or pandemics of this nature, and that resort to emergency powers, strictly so-called, should only be in limited circumstances. Secondly, I also want to say that what we have seen during this pandemic calls into question how governments use their professionals. Whether they are lawyers or doctors, there is a sense in which I don't think that African professionals have been recruited in the manner that they ought to have been in using the tools that they have to ensure that they are represented in the fight against the pandemic that we have. I would have expected that the good professors who are presented in this forum would serve as bouncing boards for the administration of President Nana Dankwa-Addo Akufo-Addo. I would have expected that to happen. And thirdly, there is also wisdom as professionals that we coordinate a lot more, even during peacetime. And I think Professor Prempe is the one who has said it quite clearly, that even if Ghana is perfect in the manner in which it has dealt with the pandemic, unless you want to close yourself until the second coming, if Togo doesn't do a good job, you have to live with the Togolese. What are you going to do? So regional coordination is very important in this regard, and the 5 CDCs that have been created by the African Union must now be given domestic legal anchors, so that even as we wait and consume the directions and prescriptions of the World Health Organization, the African CDCs could also inform the pieces of legislation that we are going to deal with. But in a nutshell, I must say that this is the kind of debate that we ought to engage in, because post-corona, even we who are legal scholars are going to have to look at the law a little bit differently. And those of you who are going to write articles out of this, emergency may very well acquire a totally different texture going forward. Thank you.
Right. Thank you, Prof. Lumumba. I think I lost you. I mean, you lost me for some few seconds.
Yes.
Finally, Let's hear from Prof. Prempe. Prof. Prempe.
So thanks for a very enlightening conversation. I think emergencies are, of course, exceptional periods in the life of a country, but they are exceptional periods that are well contemplated by any good constitution, and that includes ours. It includes Kenya's, right? And no matter the source or the origin, whether it's from climatic conditions, natural disaster, whether it's from epidemic or war, our constitution has given us a simple regime for dealing with this. And in that regime, there are roles carved for the Council of State, for Parliament, for the President, all three acting in unison, backstopped by the judiciary, of course, if there be need for judicial review. What I think that this delicate balance, which multiple centers of power within our constitutional system are represented, and are relied upon to constrain possible executive access in the period of emergency, has unfortunately been displaced. And it's been displaced in a manner, in my view, where now, depending on the government in power, its own appetite, its own inclinations, it has one of many laws to choose from. Essentially, when you face an emergency, now the message is you can take an emergency act if you want. You can take the Public Health Act if you want. You can take the Imposition of Restrictions Act if that's what you want. And if you want none of that, you can enact your own, right? All of them displacing Article 31, displacing Parliament, displacing Council of States, and just leaving the President basically moving. And I think it is this kind of, let's give the President the choice of armory. Let's completely forget about the very delicate balance regime that has been set in place by the Constitution, which is not to be used casually, right? Let's ignore all of that. Let's allow our presidents, they know best. Let them decide which law they want to use. If they don't want any, let them enact a new one. I think that going that route, I think it's a slippery slope. It takes us down a slippery slope. And I would have preferred that under situations like this, we would give at least Article 31 a try. How it works. How would this work? It is not onerous. Council of States, President's own people there, for the most part, they advise you, you proclaim, you go to Parliament, and you go back every 3 months to renew. Not a big deal, right? If you have a problem, judicial review, citizens have rights, under Article 32, that are, when they are breached or suspended, they get restored at the end of the period. This would have been a very neat arrangement in my view, in addition to giving us a sense of how Article 31 would operate in peacetime, but in an emergency during peacetime, not during war. Unfortunately, we didn't go there. And I, of course, I'm living with it, but I think that these are situations where we have to be learning lessons about the importance of regional coordination, for example, learning lessons about communicating with the population, bringing the people in, because this pandemic, for example, we know that government alone cannot solve it. If the people are actually not cooperating, you can't solve it. So there are opportunities for us to learn lots of lessons. I think that we're still learning, and I hope that at the end of it, we would have learned some interesting lessons about balance of power and the need to restrain executive power and in emergency.
Thank you very much, Prof. Lumba. I would like to apologize for the occasional cuts in network. I think MTN has sent in their apology for the fiber cuts they experienced yesterday. But that said, it's been a wonderful discussion that we've had, and I believe strongly that the conversation will not end here. I'd like to thank especially our panelists, as I know the Dean of the University of Ghana School of Law will officially send his thanks. Thanks to our participants, and thank you very much, our panelists. Prof.
Thank you.
Atuguba.
Thank you.
Thank you.